Okay, so I'd like to introduce the panelists. Obviously, you guys probably met some of these panelists already because you're in the room with them, but for those who are not, we have Curt Stofferahn, who's the chair of DRC, full disclosure. But Curt is a professor emeritus in the Department of Sociology at University of North Dakota. He has he received his MS and PhD in rural sociology from Iowa State University, and he taught in the areas of development, rural, environmental, and community sociology. Dr. Stofferann's research includes cooperative conversions and transformations, sustainable agriculture, and the impacts of industrial agriculture on rural communities. So simply what we're going to be talking about. And he served as an elected council member and secretary of the Rural Sociological Society, senator, executive committee member, and chair of the North Dakota University Senate, and chair of the Department of Sociology. He's currently the chair of the DRC. Second person we have here is Derek Braaten. Derek Braaten moved to North Dakota to work with the Sarah Vogel Law Partners over a decade ago, and has since then taken over the firm. Derek has built a reputation in the region as an advocate for landowners and landowner rights. He prides himself on taking on giants, whether those are large corporations or the government, and standing up for the land and its stewards. Derek has been very involved in numerous lawsuits and legislative efforts related to pore space and property rights. He is familiar with eminent domain and takings law related to pipelines and other energy development, and has an active legal practice representing farmers and ranchers. And then our last person, who's our most famous of all, is Sarah Vogel. So Sarah Vogel is a former agriculture commissioner. She's an attorney. She's also the author of The Farmer's Lawyer. So you guys got to grab a copy of that if you want one of those. Sarah, and I mean, Sarah, you can introduce yourself more, but that's all I have right now. Okay. But Sarah, what would tell them the years you served as ag commissioner, because some of them may not know.
8 years, 2 terms. I did not run for a re-election. I could have won.
Should have. No. So without further ado, what I'm going to do is I'm going to open it up to Sarah first. And Sarah's going to talk a little bit about the recent events with the Bill Gates land sale. And then other things around the anti-corporate farming law that she's kind of been working on recently. And for those of you who don't know, Bill Gates purchased Campbell Farms in eastern North Dakota near Braaten. And it's a whole fiasco, and she'll tell you a little bit more about that and then give you a little bit more context to set up Derek and Curt. So.
Okay. So I don't really have a title for this talk, but what I wrote out last night was, why, oh why, is Attorney General Drew Wrigley so lame on enforcement of the North Dakota anti-corporate farming law? And by now, I think it's pretty clear that the North Dakota Attorney General's office is not really interested in doing a deep dive on the legality of Bill Gates' purchase of the Campbell Brothers potato farm in eastern North Dakota. So I'm going to give a little bit of history and a little bit about my travails of trying to find out more about this. And the sale occurred on November 2nd and 3rd of 2021, so just about a year ago. And it was for $13.5 million, which is a pretty big chunk of money. And the deeds were filed very quietly with the Register of Deeds offices in Pembina and Walsh County on November 4th. And the title was transferred from the Campbells to the Red River Trust. And there was absolutely no fanfare. 4 months later, the Campbell brothers, not Bill Gates or any entity connected to Bill Gates, but the Campbell brothers filed the name Red River Trust with the Secretary of State's office, swearing under penalty of perjury that the name Red River Trust was a fictitious partnership name. And the purpose of it was to own and manage real estate. And it gave as their address, as its address, the very same address as the Campbell Potato Partnership and their farm in Grafton. And this happened on February 15th, 1922. Excuse me,
2022.
2022. And then in June, Mikkel Pates in Ag Week tracked down gossip about Bill Gates starting to farm in North Dakota. And he did a lot of digging, and you got to give a ton of credit to Mikkel Pates, that he found out that he made a lot of calls, and he said basically nobody involved in the deal seems eager to talk about it, but he persisted with his research, and his story was dynamite. He found out that the Campbell brothers had sold the farm on November 4th to an entity called the Red River Trust, and that the trustee was someone called Peter Headley. Okay, this was strange because the Red River Trust was supposed to be a fictitious partnership name run by the Campbell brothers. So it kind of looks like there was an attempt to cover it up or keep it off the radar. So Mikkel Pates tracked down Peter Headley. You and I could do the same thing just by Googling Peter Headley. And he found out that Peter Headley's address was in Lenexa, Kansas. I don't know if I'm pronouncing that correctly. And it was the same address as other companies called Cottonwood Ag, Cottonwood Farms, Oak River Farms, Midwest, and that the purpose of all of these entities was to invest Bill Gates' vast wealth into farmland. So Mikkel's story hit North Dakota like a bomb on June 9th. On June 21st, the Attorney General's office, I think triggered by a ton of calls from really irate members of Farm Bureau who wanted to buy that land, probably. The Attorney General's office, now under Drew Wrigley, sent a letter to the Red River Trust, address in Grafton, and to the Red River Trust in Kansas that Mikkel had found. The letter was signed by paralegal, and the letter asked for the trust to respond within 30 days and explain whether the sale met any of the exemptions allowed by the anti-corporate farming law, which has a much longer title, but I'll just call it the anti-corporate farming law. And that was June 21st. On June 23rd, she got an email back from a lawyer at the Fargo Vogel firm, which has no relation to me. And he said that he was the lawyer for Red River Trust, and that his client hadn't gotten the letter yet, but would the AG's office please send it to him in Fargo. So the next day, the Fargo Vogel firm, Matthew Thompson, sent an email saying that Red River Trust's ownership of the land was legal under section 1006.1, 09.1 as a trust for the benefit of an individual. And he also said that the fictitious partnership name filing of Red River Trust by the Campbell brothers was done without the knowledge of the Red River Trust. Who knew? So, on June 29th, just days later, that was the extent of it, an email from an attorney who told her this. She said she sent a letter back assuring Mr. Thompson, we are satisfied that the Red River Trust current ownership and lease of the land to Campbell Farms is in compliance with North Dakota Century Code Chapter 1006.1. Accordingly, we are deeming our inquiry file inactive. That's it. But the public wasn't inactive. A lot of people and organizations wanted to see the actual records in the actual trust agreement. There was criticism of the AG's office for deeming the acquisition legal after such a shallow investigation. I'll skip over all the criticism that's been leveled at the AG's office for simply taking the word of an adverse party. For example, Derek and I. Derek sues a client of mine, and I tell him, my client's innocent. What do you say, Derek?
I disagree.
Yeah. And then what do, Derek?
I sue.
Yeah, you get discovery, you make them swear things under oath. You do stuff like that. But that's not what the North Dakota AG's office did. So they didn't review any documents at all, none, not one. So there was a lot of criticism. And then I went on the Joel Heitkamp show, and then the next day, Drew Wrigley said, I want to be on the Joel, or he said, I will be on the Joel Heitkamp show. And when he was on the Joel Heitkamp show, he said that I was uninformed because he knew that the documents or a document was coming or was on its way or was already there. So silence. Nothing further. Nationwide, it said this sale, the AG's office says this is illegal. So in September, I made another request. And again, there was open records is pretty good. You know, under the open records law, if there's a document that isn't exempt, and anybody requests it, they have to give it to you, and they generally do it pretty fast and they forcing it. So I was making these open records requests. So then I got another tranche of documents basically saying, let's talk, let's visit, let's, and again, now suddenly there's still Peter Headley, the trustee. And then a guy shows up by the name of Mike Rodden. And who is Mike Rodden? He's $1 billion corporation called Cascade Investment. 71, so a lawyer for a 71 visit. So this is very concerning. And so around this time, I was saying, Drew Wrigley is not going to look into this. He should appoint a special assistant attorney general because he's obviously got a conflict. First of all, he was appointed by Governor Burgum. Governor Burgum was paid, I've heard, $1 billion for his company, Great Plains Software, to Burgum when he ran for governor.
250,000.
Wow.
It's a lot.
Yeah.
Yeah.
How would you know that, Shelley?
Oh, that's right. You noticed, like that's sort of like serious competition. So, so what happened then? I'll share, thing happened. So then on October 16th, in preparation for this DRC meeting, I did one more request because, like, unlike old days, if, as I recall, if somebody made an open records request for documents and they weren't there, but they were created later, the AG's office would send them, but they don't do that anymore. So if you have an open records request, Attorney General on and after September 13th, which is my last request, with respect to Bill Gates or Red River Trust purchase of farmland. I wasn't expecting a thing. But to my surprise, I did get a document. The thing about this document when I got it is that it's dated August 10th. And I had been asking for this document subsequent to August 10th, but apparently the AG's office didn't get it. And it was also funny because it was like the front page and the back page, which is one sentence, if you can see that. And it's basically saying that Peter Headley saying, I'm the trustee for the Red River Trust, and Bill Gates is the sole beneficiary of the Red River Trust. So everything's, basically everything is hunky-dory. Now, they did not have this document when they said it was legal. And this is what they got. And they got this on, anyway, I said, well, when did you get this? That indicate the day you got it or the day that how it was received. And then I got another few disclosures. And basically the Solicitor General had an hour-and-a-half meeting with the Vogel firm, no relation, and had gotten this at that hour-and-a-half meeting. And then he'd uploaded it on October 12th. No, yeah, on October 12th. So now it is almost 1 year since this land passed hands. And it looks, I mean, he's basically saying it's a trust. Under the law, trusts are exempted. But when I read the legislative history of this law, it appears to me that this law exempting trust was intended to exempt a trust where, say, a bank is managing something for managing land for somebody who's ill, disabled, too young, that kind of thing. That's the kind of trust they're talking about. But that's not the kind of trustee Peter Headley is. He's not taking care of widows. He's the head of it for Cascade Asset Management Company, and he's been on that job since 2017. Before that, he worked for MetLife Agriculture Investments, and this is with him. He's no country lawyer out of Walsh County. He's the general counsel of Cascade Asset Management Company, which handles investments for the Bill Gates and Melinda Foundation. And the Cascade Investment LLC, beneficially owned by Bill Gates III as the sole member of Cascade. So North Dakota doesn't keep rich people from owning farmland. That has nothing to do with it. It does bar corporations with limited exceptions from owning farmland. And that's, I think we have, as was said, we have probably the best anti-corporate farming law in the country. And we've had it for 90 years. So, so then you read up on Bill Gates and farmland, and he is now the largest farmland owner in the United States. And that's because farmland is a good investment. And it's, you know, like if his other investments go down, farmland might go up and so on. And I'm neither a detective nor am I an investor, but I was reading quite a few stories about this, and NBC News had a story that public records indicate that Cascade Investments has bought its farmland through a web of at least 22 limited liability shell companies across the country. In Florida, it used Lakeland Sands, Florida, founded in 2012 with the same address as Cascade Investments in Kirkland, Washington. North Florida used another name. So people have been finding out that there's this network of shell companies. And sometimes it's a shell within a shell within a shell, but it all goes back to these great big corporate entities in Washington state. And here we have the lawyer for this great big corporate entity contacting the Attorney General. So what does it mean? I think it means that Bill Gates and his team of legal and management executives are playing North Dakota's Attorney General's office like a fiddle. Red River Trust, by the way, is not registered to do business in North Dakota. The only Red River Trust is this fictitious partnership name, which is still there. So it may be a trust. On the other hand, it may be a facade for Cascade Investment, a multi-billion-dollar limited liability corporation. Why are Peter Headley, the manager of these investments for this big corporation, and the general counsel of this great big corporation, why are they involved? And why do they want to talk to Drew Wrigley? So why hasn't Drew Wrigley looked a little deeper? And I think it's basically he doesn't want to. The governor has come out of the weeds and has now said out loud to Ag Week that he wants to repeal the anti-corporate farming law. So I think that they're just getting a head start, so to speak, and the AG's office is simply not curious at all. I mean, this is their investigation. This is it.
The back page.
The back page.
Oh, the back page,
Yep.
sorry.
If you look at the back page,
The back
that's their
page.
justification right there.
Yeah. Bill Gates is the sole beneficiary of the trust. Okay, so now it's the Red River Trust, hey, April, was organized under the laws of the state of Washington. And I checked out the laws of the state of Washington, that it is, trust. And you know what? They have a whole bunch of kinds of trusts. They have trusts that are called something I didn't know about, a Massachusetts trust. It was invented in Massachusetts. And it basically walks like a corporation, talks like a corporation, it acts like a corporation. And is this a Washington trust under the laws of Washington state? I mean, a Massachusetts trust, which is in essence a corporation? Or is it some other kind of a trust? I mean, we have, if you look at the North Dakota Secretary of State's website and type in the search word trust, hundreds of trusts come up. And a lot of them look a great deal like corporations. A lot of them are from out of state. So do we know whether, I mean, here we have a situation where there's this trust. And then, but who is running the trust? It's high-paid corporate executives at a multi-billion-dollar company. They're the ones who are calling. And this brings me back to what can we do about it? Now, there is a private right of enforcement of the anti-corporate farming law. But you know what? If you lose, you have to pay the other side's legal fees. So I'm really not aware of one instance where anyone has used that private right of enforcement. So one of the things that we could do, and I suggest this is something DRC may want to do, is to alter the private right of enforcement so that fee shifting does not occur, so that you can go and pay your own attorneys, let them pay their attorneys. And or maybe if you win, get your attorney's fees paid back, but not have the sanction of being of having to pay for the other side's attorney's fees. That would be a small change. And another one would be that this was, and the law says that the registers of deed are supposed to report all sales, corporate or back in the day, as I recall, we used to get letters when I was an assistant attorney general that the registers of deed would say, hey, I think this doesn't look right. And then the investigation would commence. And the investigation did not come from a paralegal. It came from a lawyer who wrote a really nasty letter and demanded responses. But the county recorders of deeds are very busy. And I think if they knew that if you see something that isn't an individual, send that in to the G's office so that can be investigated to see what kind of a corporation is it, or maybe it isn't a corporation, maybe it's legitimate. But that would expose some of these shell entities, shell trusts, fake partnerships, and corporate officials pretending to be just your local friendly trustee. And then maybe they could sue even if the AG's office is so compromised it won't. And then another thing we need to do is pull back the curtain on these sham owners and sham trusts that are being used to get around our laws. And I was like late last night, I was Googling, I said, what can I offer as hope to the Dakota Resource Council and all the people in the audience? And I found something, like it was about 2 a.m. And that's basically the doctrine of piercing the corporate veil. Now, if this is a trust, I think we need to pierce the trust veil. And North Dakota courts have been doing this. I found this great quotation from a 1918 decision of the North Dakota Supreme Court. And it says, no corporation can become so securely organized and protected as a legal entity as to become a cover for wrong and fraud, and thereby defeat the rights of innocent parties. A corporation cannot be greater than law and equity, nor by reason of its legal entity be immune from answering for fraud and wrong. In such case, the protecting hands of equity will brush aside the outward forms of the corporate entity and analyze the foundation, purpose, and intent of the corporation. And if the purpose and intent of the corporation are not embedded in good faith and are but a cover for wrong and fraud against innocent, the corporate entity will afford no protection for such wrong and fraud in a court of equity. McFadden versus Jenkins, and you can all stand up and applaud. 1918, but it isn't a dead letter because it was quoted I found this in a 2007 opinion by Justice Carruthers. And you know where else it pops up? In the North Dakota Attorney General's Consumer Fraud Division letters to, I'm serious, the Liberian Center for Growth, all these, invest in Africa, blah, blah. Well, so it pops up in these consumer fraud. They know about this. So why? I think this is something that could be done if there was to get through it. You can pierce the corporate veil. You should be able to pierce the trust veil as well. So I think it's just this idea of that this is a trust by Bill Gates, the individual is, I think it's a sham. we need to brush aside the outward form of the trust or get to the bottom of it. You know, I don't know, maybe it's perfectly legitimate. But it doesn't look right. It doesn't smell right. And I think we should not give up. We should continue. And from what I've read in the paper, it's not just the lefties that are upset about this. There's a lot of people who are Republican and conservative. There might be support for these amendments in the legislature from on a bipartisan basis. And I think we need to do it because otherwise the anti-corporate farming law is going to be a dead letter. They could an LLC sue the LLC, and then if they lose, then the next thing would be, well, does you dissolve the LLC that sued? And yeah, I think that could be done. The other trigger is that to file a lawsuit like this, you have to be a resident of the county where the farm is located, where the land is located. And so and Derek knows a lot about this, we all do, during the DAPL, when the oil company or the pipeline company bought, what's the name of the ranch?
Is it Cannibal Ranch?
Yeah. Cannibal Ranch.
Cannonball Ranch, which was 7,000 acres, I think. Corporation just bought the Cannonball Ranch. And the AG's office just sat silently by for quite a while. And then they finally sued. And then, they entered into a non-enforcement agreement, which is like, what? What is a non-enforcement agreement? The Attorney General for Cannonball Ranch agreed not to enforce the law and signed a deal with the pipeline. I mean, it was amazing. And then after a while, the pipeline company was supposed to sell it when the people left, they all left. It's just, but they still own the ranch. But what they did is transfer it to one of their executives.
Mhm.
So how about piercing that corporate veil? That's absurd. He didn't pay millions of dollars to buy this. I mean, it's still owned by the oil pipeline company, and the word is out. I think the lawyers who are working on, the defense side, they know how to go about this. This is not rocket science. But I do like your idea of the LLC, but you would have to make that LLC a resident of that county. I don't know how that would be done.
Oh, they would have to be a resident too.
They have to be, like if you want to sue Bill Gates, you have to be a resident under the law as it now is. Only a resident of the county where the allegedly illegal purchase occurred has the right to sue.
So that question would be, is an LLC or corporation a person?
A
Or a
resident.
resident person?
I don't know. Like that's another issue.
He's still practicing. So he should know the answers.
Can I ask one? Is there any judicial discretion as to whether you actually do, or is that in law that if you lose, whoever loses has to pay?
It's in the law.
It's in the law. I'm just wondering if that went in, if that was a bill that was introduced in the legislature, should it be judicial discretion rather than, shouldn't we allow judges to make that decision, or should we not let judges make that decision as to whether they can charge the other side?
What I think would be best would be the party that is seeking, basically acting as a private attorney general should never, ever be assessed attorney's fees of the other side, never, ever. However, if they win, they should be afforded And there's a lot of parallels, like consumer protection laws, equal credit opportunity, those kind of laws. There's fee shifting, but there's no sanction on the party that brings the lawsuit, like the civil rights laws. You can sue and you can lose, but you don't have to pay the other side's fees typically. So that there's a lot of laws like that. And it kind of evens the power of the citizen with the power of the big corporation or big government.
Are there a lot of cases like, or just in corporate farming, is that happen in North Dakota? Or is it in a lot of different areas where you can be sanctioned like that?
I think it's pretty unusual that there's a automatic fee shift.
Yeah. Yeah, there's more situations where what you were saying, they might say the court has the discretion to shift fees one way or the other. And so in eminent domain, that's the case. It says that they may award fees, but they actually just always do as a matter of practice. But
If you
this,
win.
yeah, well, not if you win, even in eminent domain. It's
Oh.
just you go to trial and get an award. And even if you get less than they offered, recent decisions have said you still get your attorney's fees.
Yeah,
The corporate farming law, it's fairly simple what Sarah's talking about, because there's two sentences, and one says if such action is successful, all costs of the action must be assessed against the defendant and a reasonable attorney's fee must be allowed the plaintiff. Then the second sentence, if judgment is rendered for the defendant, such costs and a reasonable attorney's fees for the defendant must be paid by the plaintiff. So you literally just delete that last sentence, and then it just has a provision for the plaintiff and not for the defendant.
that's why he's such a good lawyer. He's told us how to do it.
There's two questions.
Come together nationally.
Oh,
Okay, so the question for those who couldn't hear on Zoom is, is there a way that she was asking Sarah specifically, how can this kind of practices, even without corporate farming laws, because what's happening is corporations like Bill Gates and company are buying a lot of farmland. Now, and farms are no longer being owned by corporations, etc. How do we prevent this from happening? And just asking Sarah and others whether or not there's answers for that. And Sarah had one. Sorry.
yeah, my answer would be that's let's take the first step here in North Dakota first, and then move on from there. But I love your big picture, your great aspiration. I'm just too jaundiced to go that far. I'm just,
Andrew.
Two-part kind of. Is there some way this could be dealt with through, let's say, the Walsh County State's Attorney's Office, since this is in Walsh County, or is this a statewide jurisdiction? That's interesting. And the other is that, given that this sounds like fraud, if a corporation commits a crime, can a corporation as a person be held criminally liable for the crimes it commits?
So the question for the chat is, does this jurisdiction only account in Walsh County, or is this a statewide jurisdiction? And two, if a corporation is a person, can it be held accountable for fraud and criminal? Yes.
as far as I can see from the law, and Derek just muttered the answer, and that is that in North Dakota, under the law as it is written, only the Attorney General has that enforcement power for governments.
For the corporate farming law.
For
I
the,
mean,
yeah,
if there's criminal fraud, then yeah, the state's attorney could be investigating that.
Okay, I've got a question from the chat. So Merrill Pepcorn asks, is the current system of the plaintiff paying the defendant's costs designed to at least somewhat prevent frivolous lawsuits?
yeah. Let me try to answer that.
Oh, it's really sensitive. So
Oh,
like you
sorry.
can,
Okay.
yeah.
Sorry. Hey, Merrill, that's a good question, and I suspect that that was put in place years ago to prevent frivolous lawsuits and any lawsuits. And it's worked. I mean, there's been no private right of enforcement. When the Cannonball Ranch was purchased, I made a number of phone calls around, and what I was looking for is a resident of, I think it was Morton County, who was young, who wouldn't mind going bankrupt. And there was nobody, and I made this request to the tribe. Do you have anybody who's a member of the Standing Rock Sioux tribe who lives in Morton County, who wouldn't mind going bankrupt? And there's nobody came forward. So, but that's all there is. That's all there is. I mean, it has to be somebody with nothing to lose who can go out and hire an attorney to go sue the biggest, the most wealthy person in America.
They have to have enough money to hire an attorney, but not enough that they care about losing it. Should be easy to find.
Yeah,
Or
yeah.
a pro bono attorney. But what I would say is, I think that's what I was saying earlier about changing shall to may. Usually, even if you have it where it can go both ways, where both like the defendant and the plaintiff could get their fees, that's where if you say to the court may award fees, I think that courts are going to use their discretion. And if it is a frivolous lawsuit, then they are going to award those fees. But if it was a legitimate dispute and you lost, but it was still a legitimate dispute, they probably won't give anyone fees because they'll say both sides had a good argument, so both sides bear their own fees.
Yeah.
Is it original to the, is it part of the original language of the law? That's been there the whole time?
No, I think the original law was an initiated measure, and it didn't have that. It was added at some point over the years, but I don't know when. I have not dug deeper into that.
Jane has one.
This may have been covered when you started, so I apologize because I was downstairs grabbing handouts. Why do we think Bill Gates is buying all of this? Like, I've heard different theories, and he is the largest landowner in Nebraska also. So why do you think, or if the panelists, why he's buying off all this land?
Okay, so the question that we have is, why do you think Bill Gates is buying farmland?
From what I've read, and there've been a number of news articles about this, and is that he's buying farmland because it's a good, safe investment that's counter-cyclical to many of the other investments he has. So it goes up typically. I mean, with the exception of 83 to 85, which I talk about a lot in my book, and one or two other years in the last 90 or so years, farmland typically goes up. And right now it's going up a lot because of people who are parking money in farmland. So he's doing it to make money. And people have wondered, are you doing this to be green, or, to increase your plant-based food? And I'm a vegetarian, but like, I'm not eating that stuff that he's making, that he's growing in a lab. But it's to make money. From what I've read, they're not instituting better environmental practices or planting trees or anything. In fact, it seems as though the land is being bled even more than it was under other ownership, the prior ownership. So it's just for money, like he doesn't have enough of it.
That's how you get that much of it, though.
Oh. I wouldn't know.
Yeah.
Shelley, did you have a question? Too?
Oh, so instead of going a legal route, since it's the AG, which is a political position or elected position, what about the political, what other groups in North Dakota are against this and working on this to kind of bring this up to the consciousness of the individual voters and stuff?
Well, I think there's actually quite a bit of unhappiness about Bill Gates buying North Dakota farmland. And it's coming not just from Farmers Union or Dakota Resource Council members, it's coming from Farm Bureau. Doug Gehring was quoted in the paper as saying he was getting phone calls from people who are livid about this, and which is ironic. But I think a lot of wealthy people thought that if the corporate farm law were weakened, they would be the ones to benefit. They were not expecting the likes of Bill Gates to come in to be their competition. So it's not, I'm not saying it's intellectually consistent, but I believe the Farm Bureau is as upset or more upset about Bill Gates coming in as is the Farmers Union. But nothing is organized, and the Attorney General, Wrigley, is probably going to be, I mean, I'd say it's 100% certainty he's going to be elected again for a 4-year term. And he's not being responsive to any of these complaints. If this piece of paper is all you get after all these months of alleged investigation, his heart's not in enforcing the anti-corporate farming law.
I do have a
We
question.
probably have to move to the next panel.
Yeah.
But we
No,
can
I was
hold the
gonna
questions.
tack on to that, actually.
Let's hold the questions till because we gotta move forward.
Yeah.
So
Derek
Kurt, if
wants-
you want to
you
go
wanna add?
next.
No.
I'll add
Okay.
it in line.
Okay.
So what Kurt's gonna talk about most likely is his research specifically into
Ties into that.
what happens when industrialized agriculture comes to communities. So he did research, and he's gonna talk about this more, but he did research, his dissertation is from 1985, and it's truer now than it was then. And he's gonna talk a little bit about that, and then he's gonna also talk about like what is happening to family farms, because family farms are still family farms, but they're not the same family farms that we had 40, 50 years ago. They're much larger and they're becoming more industrialized. So he's going to talk a little bit about that dynamic. And a lot of that is not the fault of the farmers. Some of you here in this room probably have more industrialized operations because that is the only way to survive. So Curt will talk a little bit about that and the dynamics that essentially are affecting family farms from a sociological standpoint, and then just from like just a community standpoint.
When I saw the title of this panel, I grabbed my dissertation off the shelf, my 37-year-old dissertation I hadn't read since 1985. And I was reading through it and I thought the title was Family Farming, Persistence, Decline, or Transformation. And I was reading through it and I thought, damn, this is good. It's theoretically sophisticated, methodologically rigorous, statistically complex, and the results are prescient. They predict. I did a Markov chain model. If you can marry the dialectic with a deterministic model, it worked. And it predicted exactly what was happening in agriculture in the year 2000. I went back and kind of cursorily looked at the statistics for agriculture. I was right in the money, not exactly I mean, the trends are there, but the numbers aren't exact. Because, the dialectic always says that forces can be mediated by human intervention, human agency. But it predicted exactly what's happening, that family farming is persisting as an organizational form, but it's declining in terms of numbers in the same way as being transformed and how it is operating. And I think we see that what I considered a family farm in 1970, when we first moved to North Dakota and bought our family farm, is considerably different than what it is today. in my dissertation, I looked at the characteristic of used contemporary critical theory and differentiated family farming into three different types, which was first was the rural working class. They may live on the land, may raise a small amount of agriculture production, essentially are working off the farm. There's a rural working class. There was the family farmers, and then there was a larger family farmers, which are semi-capitalist. They retain the elements of family farming, but they're fully integrated into capitalist relations. And so, and then I looked at the second paper was to look at bring some coffee.
Yeah, you too.
Yeah.
Was to look at those trends within agriculture from the decennial agricultural census from the 1950s through the 1980s. And I also predicted this wave of consolidation, expansion, accumulation would vary by long ways of capitalist development. It pretty much bore that out that there was an expansion of a larger farm size category in expansionary periods and a contraction during contractual periods. And there's always the residual category, which is the working class, was always continually expanding, but the family farming class, the simple commodity producers who call it, was always shrinking. And so I thought, well, why did I ever do anything with this? Well, when you get your PhD and you're looking for a job, and it was the middle of the 1980s, during the farm crisis, no academic place was hiring. I went through more depressing interviews. One was actually frozen during the interview process at Texas A&M. I'm glad I didn't go there. But so I ended up working part-time in the department and postdoc, and I worked for North American Farm Alliance for a while, for about a year, to end up by fortune, good luck, happenstance, a divine will, end up in North Dakota in a one-year position, Economic Development Commission.
Yep.
And worked on a project there saying, okay, this is not working right now during the farm crisis. What do we do different to provide alternative forms of income for family farmers? And that was a project. And the results of that project became incorporated into Growing North Dakota, the governor's center champion through the North Dakota legislature. So a lot of the work we did there, and I can't claim credit that I was assisted by Jeff Weisfenning and
Sarah Vogel.
There's a lot of people that helped me into that process. And so a lot of that, what we did became incorporated in Growing North Dakota. Speaking for a few years, I ended up at UND, again, by divine will, happenstance, or good luck, I'm not sure. But in the early 2000s, I was asked by the AG's office to provide expert testimony for defense of the corporate farming law. And I don't see it. This is 2006, which was North Dakota versus Crosslands. And I just didn't feel up to the task. And I talked to my colleague, Linda LeBeo at Ohio State, and she had done similar testimony defending the corporate farm, the social justification of corporate farming law, and challenging the corporate farming laws in Nebraska and South Dakota. So I took her research, updated it, and then I gave it to AG's office. I was signed an affidavit, but I was never deposed, never called to testify, and asked Charles Corvell, why is it, I'm not being called? He said, oh, we cited your research, and trouble is so damn good that no one dares challenge it. So they're just going to argue the law and not the social justification of it. So I subsequently called upon Cook Waterfowl versus North Dakota, Stenjum versus National Audubon Society, North Dakota Farm Bureau versus Stenjum, and North Dakota versus Dakota Access Pipeline. And again, I had to testify that the research was current. I had to again go back to literature and see if there's anything new that come out that would significantly change our conclusions, and nothing did. So I signed an affidavit, never called to testify, and which was fine. I'm glad I didn't have to go testify because I didn't want to be grilled by an attorney, but I'd asked the attorneys from the AG's office, and they said, they don't want to touch it. The social justification is so consistently clear that they can't argue it. And they're not competent as attorneys to argue sociology. only sociologists are competent to argue with this meritorious sociological research. So it said, don't worry, you're safe. But the results of that research on the social justification was well, I should say that research is so popular. I posted it on my website. It's also posted on the Attorney General's website. It became downloaded so many times that they took it off the AG's website. And I think it was embarrassing the AG's office. They had a research up through which they paid for, supporting the court performing law. And they didn't think they liked having it there. But it was on my website and it was being downloaded so many times that I called my colleague. I said, we got to do something more with this. So we prepared it and we used only the peer-reviewed articles. And we had it published in Agriculture and Human Values. And it was that article in Agriculture and Human Values in the 95th percentile of all articles. It's the highest cited article in Agriculture and Human Values. And so we had something there. And so we looked at just the peer-reviewed literature, which gave even more rigorous substantiation for our thesis that industrialized agriculture, we didn't talk about corporate agriculture. Corporate is part of industrialized agriculture, but it's only one part. Because we could not, there's only a few cases talking about states with or without corporate farming laws. And even that research found that states with corporate farming laws, no matter how weak or rigorous they are, have a more dynamic family farming class. We looked at the broader case of industrialized agriculture. And of those 51 studies, 82% provided evidence that adverse impacts. And while those 57% reporting largely detrimental effects and 25% some detrimental effects. These were reported in studies using various different types of research designs across different time periods and different regions. So it's a generalization that you don't find very often in sociology, that across time, across region, and across methods, the results are consistently supporting the thesis that industrialized agriculture has detrimental impacts on rural communities. And so I was pretty proud of that research. It's probably some of the research I'm most proud of, the work I've done, other than some of my work on transformations of cooperatives into non-cooperative forms. And Sarah knows about some of that. What I've looked at recently is what's happening to family farmers as they become transformed. And part of it is I've seen how family farmers are becoming integrated, and this is part of this industrialization process, integrated into vertical chains. And I can think of friends of mine in Sargent County, or actually in Dickey County, have a CAFO. And all they're doing is they're providing the land, the labor, and the capital. And a corporate integrator is coming and providing the hogs and the feed and the management, the veterinary services. Now, the joke is they own all the live hogs and the family farmer owns all the dead hogs. And so when they were coming into Sargent County, we decided, well, we're going to fight this. And I talked to my good friends, Bob Banderette and Paul Matthews, and they're both involved in DAPL and also now in Summit. And they're also township officers. And they said, we have no way to fight this. First of all, it's way out there. It's so far away from any habitation. It's 5 miles away from the closest farmstead. It's probably if we're going to put somewhere, it's probably the best place to put it. But we're concerned with the environmental impacts, the social impacts, health impacts. They said, we can't fight this. We haven't got the resources to fight this. We're seeing it across North Dakota, where out-of-state corporations want to set up CAFOs and using the guise of a family operator to do it. They essentially become indentured servants because they're working for the boss. They're working for the corporation. This is how they're making inroads into North Dakota. That's how they made inroads into Iowa. These CAFOs in Iowa, most of them are owned by family, owned. They provide the land, labor, and the capital. And the corporation provides the hogs and the management. So you think about family farmers, ownership, management, and labor are one and the same. But the minute you start separating ownership and management and labor, when family farmers are just providing the labor. And for ownership, management, capital, and labor, they provide the capital and the labor and not the management and control and ownership. They don't have a family farm anymore. Richard Rodefeld wrote about that a long time ago in the early 70s. They came up with that typology of ownership, capital, labor, and management. And when they're fused together, you have a family farm operation. When they're separated, you become differentiated into a simple commodity from a family farmer to a family working class or a capitalist class. So that's what I'm seeing in North Dakota. And I think our corporate farming laws, there's a hole in that big enough that Derek could probably talk about to drive a truck through to allow this to happen now. That concerns me. The other thing that concerns me, the Grand Farms, you've probably heard about this. The USDA invested about $1 million into it. Governor Burgum's championing this as a wonderful thing. Even our farmers union is on this board of directors and supporting it. But what is Grand Farms? They're taking robotized agricultural management techniques to operate a farm. If you take it to a logical conclusion, you can have one farm per county operated by RDO Offutt, a family corporation owning farms. They could operate that farm out of the RDO tower in downtown Fargo through robotics. That's the design that Hiram Draki, the agricultural historian at Concordia, famed agricultural historian, was advocating for. One farm per county. And we could be going that route. And it could be a family owned, but not resident on the land. And then we have a bunch of working class people out there living in a rural slum, like my community of Cogs was become as a rural slum. And people work there, they're working class, but they're living there because of cheap housing, substandard housing. And no one's managing, no one's taking care of it. But that could be a future of agriculture. Rural communities become resident rural slums, but for working class people working on corporately owned operations. So I'm not a big fan of Grand Farms. So I made that known. I'm sure I think my friends at Farmers Union probably read my Facebook post and they're very happy with me either. But I'm afraid that might be the future if we don't exercise some agency and say, no, this is not what we want. But I don't see anyone taking action now to say, especially when Farmers Union is on board with Grand Farms. I don't see farmers challenging these exemptions to corporate farming law because I don't think they want to draw attention to them because they would draw attention. They'll say, others will say, oh, we can do that too. So I guess I'll turn it over to Derek. That's where his expertise.
Yeah. Well, that got me really fired up to start,
Dystopian.
yeah, start fighting about corporate farming laws. Go ahead.
One question. Really quick.
Yeah.
I mean, the driver are the farmers, right? They identify as farmers, they're family farmers, they have been for years, hundreds of years. So that's the problem, right? That's the only way. They do this in North Carolina with chicken farms.
Mhm.
So how do we help the farmers? Because that's why they're doing this, right? Is because it's a way for them to keep their family farm.
Mhm.
So how do we fix that problem? That's a long
That's
question.
what
It's job security.
Well, I know in poultry farming particularly,
Repeat the question or.
Sorry.
Yeah. What if family farms engage in these type of things that are really detrimental to their own interest?
Right.
Yeah. Part of was, thinking of the Grand Farms and especially with technology, it's a technological treadmill. I have friends, damn good friends back home are becoming very large farm operators. Part of it is expanding so they could bring their sons in the operation. And that's the only way they can do it is by becoming larger to bring their family into it. Also, my own family, my cousins are doing the same thing. As the two brothers now brought their sons in the operation and they become a very large farm. They're still providing the management and the ownership and the control and the labor. But when they have to adopt all new technologies to keep ahead of the curve to reduce their operating costs. And so it's a treadmill. And only those that have the resources, the capital to adopt the technology are able to reap the benefits from increased production. But those that can't adopt it are squeezed out. So the technological treadmill is operating all the time. And that was going back to Willard Cochran back in the late 69. He wrote the book, which I read in the ag policy class at Iowa State, taught by one of the famous ag economists, Neil Harrell.
Mm.
So, in the end, Neil was saying, I'm not sure we want to do that, go down this route. But it's a technological treadmill. They're forced, the margins are so low that they're sold a bill of goods, especially the CAFOs. There's only thing to save their operation.
And honestly, for Grand Farms, it's just outside of where I live. They got $10 million of COVID money to invest in that. Burgum announced that did acknowledge that when he was at the opening ceremony. And the other thing I like to say about Grand Farms is that it's solving the problems that corporate farming has created.
Derek, now,
Sorry, Dave.
sorry, Derek.
No, that's fine. I'm actually just going to dovetail. So I'm going to talk about pore space and property rights and some of that, but I'm going to start with the corporate farming law because I can fill in at least one little piece that's been discussed and use that to pivot into what I was going to talk about. But the most recent case, other than the stuff that happened with Dakota Access, was the Farm Bureau challenge to the corporate farming law. It was a recent direct facial challenge. And there was an exception or a loophole that came out of that litigation. And that loophole that came out of that litigation is also being used right now. And that's why Dakota Access was able to buy the Campbell Ranch and why some of the other stuff we're seeing is happening. Not the Gates Trust, I don't think, but hearing some of what you're saying, it could be. So what happened was, I'm going to try to leave out some of the legalese, but essentially there's an issue where an individual state can do a lot of things, but where it goes too far is when it starts regulating commerce between other states. And what we say is, no, the federal government regulates commerce between the states. If we allow one state to start doing that, it's going to break down commerce everywhere. And so with the corporate farming law, what they were saying is you have an exception to the corporate farming law. And the exception to the corporate farming law allows a family farm corporation to be a corporation that owns farmland and operates farmland. And you can't do that because that discriminates against out-of-state corporations. And they were saying it discriminates against out-of-state corporations because it says that you have to be either managing or in control of the land. I'm going to try and pull the language up. So you have to, one of the members of the farm corporation has to be an individual residing on or operating the farm or ranch. And so the question is, well, what does that mean? And if you have to be an individual residing on the ranch, then that does discriminate against out-of-state corporations because obviously they don't have someone living on the ranch, they're an out-of-state corporation. So what they said, the Attorney General's office made the argument that no, the exception is fine because when it says operating, it says an individual residing on or operating the farm and ranch. And historically, we've always understood operating a farm and ranch to require you to actually be on the farm and ranch, but no more under the corporate farming law. And you can operate a farm or a ranch from a tower, and it doesn't even have to be in Fargo. It can be in New York City. And that is considered operation under the statute of a family farm, ranch, or farm. And so because of that, and that exception, that sort of argument came up in some of the prior cases, like the Crosslands case, but it was really that sort of interpretation from the Attorney General's office that, number one, creates a giant loophole in the corporate farming law. But number two, just to be fair, it was also the way they prevented the rest of the farming law from going down. And so, but that's the problem, is I think that what you're going to see is constant attacks on the corporate farming law. And although you can understand why the Attorney General might take a specific litigation position in that lawsuit, what's going to happen over time, if that keeps happening, is there's not going to be much left of it. And so when you say, for example, that you don't have to actually live on the farm anymore to meet that exception, What it allows is some mid-level manager from Dakota Access to now operate the Cannonball Ranch and be owned by a dummy LLC that was set up with him as the sole shareholder. And so it's literally that loophole that came out of that challenge to the corporate farming law that allowed Dakota Access to do what they did. And that's why the Attorney General was able to sign a non-enforcement agreement. They literally just pointed back to that litigation and said, we can enforce this because that's the position we took there. And so you're fine. So, but unfortunately, that opens it up for farm corporations from around the country. And the other thing I'll say that I hadn't thought of until today is what it also opened up is they also had to interpret the word domestic, because they were again saying if domestic means North Dakota, again, you're discriminating against out-of-state corporations. So the Attorney General's office says, no, domestic doesn't mean North Dakota, it means just United States. Like as long as you're within the United States, that's what domestic means. And I don't think that was what it actually meant, but they can interpret it that way. And they did. And so now what they've said is it's domestic doesn't mean North Dakota corporation. It means any corporation in the United States. And again, it was probably, to be fair, that or lose it all, unless we wanted to get into a real big fight over it. And frankly, some of us did, but the Attorney General's office is in the driver's seat in one of these actions. And so they wanted to preserve what they could and take this sort of out by giving these things away. But the interesting thing that happens then is different states define corporations differently. And what might be a trust or an LLC in one state, another state might consider that a corporation. And so now what I didn't realize until Sarah was saying this about the trust, she's right. When we said that you can be a domestic corporation or LLC from any other state, now we've got a whole new can of worms that we just opened, because what we're saying is they can organize themselves under the corporate laws of another state and we'll recognize that. Well, sure. Will we though? And the question is going to be, how different is that corporation from a corporation in North Dakota? And is it one we would recognize as a corporation, or would we call that a trust? And those are a pretty high level analysis that I don't think the Attorney General's office is going to start engaging in based on what they're doing here. But that's really the level of analysis that they're going to have to start doing if they're seeing out of state corporations, trusts, LLCs, more so corporations, LLCs start filing these like this, is there's additional levels of analysis that are going to have to be done. And from what we've seen,
As usual.
from what we've seen, I don't think that's going to happen. There's a good pivot here for me though, to get into a few of the things I was going to talk about, because I moved out to North Dakota to do what Sarah was doing, and I worked with her. But the year I moved out here, the oil boom started, and within a few years, I was doing as much in the oil patch as I was doing agricultural law, which was what I originally moved here to do. And I've since found myself neck deep in a lot of the oil patch stuff and energy law, and more recently pore space stuff. I still do my best to do as many NAT appeals and crop insurance arbitrations as I can, but I get a lot more calls on pore space issues these days. But one of the things I've noticed that really ties in some of the work I'm doing to what's going on here is whether it's a CAFO or a special waste facility or a wind farm or a solar farm or a disposal well, or just payments for a couple of well pads going on the property or a pipeline easement. A lot of the energy development is resulting in what we'll call supplemental income to farmers. And I think that from my perspective, a lot of what I see is, I think that there are a lot of family farms in North Dakota that are being saved, you could say, by some of these payments, at least financially. But I think the discussion that we're having here is one you want to have, because you have to think, you know, it's a rational decision for a farmer sitting there thinking, I don't have any money in my bank account and I need money in my bank account, or I can't buy seed. What am I going to do? Then someone comes and says, I got money. I mean, these are rational decisions these farmers are making in their lives and in those contexts. But what we can say is, you get a CAFO on your property and at some point you become some sort of tenant farmer or tenant laborer. That's not what the intent was of that farmer when they brought that CAFO in, but that's what the intent was of the people running CAFOs. And so I think that part of the work I do is trying to help the landowners and the farmers find that balance where they can have some of these projects on their property, but they can also protect the land and protect the community and protect their way of life. And and frankly, with some of these, I don't know if there really is a way for that to be done. What I would say is, maybe it's the Minnesotan in me, but for me, seeing like wind farms, for example, I know out here in North Dakota, that's considered an eyesore. And I think the difference for me is really just coming from Minnesota. I'm used to trees and everything. And so I think people out here on the prairie see anything that gets built on the prairie as getting in the way of the view, whereas Minnesotans think the view is the trees in front of you. So we don't think of it that way, but
Windmills are just big trees.
yeah, it's just a really big tree. But my point is that, there are things like that with a wind farm where, the negative impacts are really, I don't like that and I don't like it on my property. But it's not like you're going to change the entire fabric of this community over time. And so there's differences between these different things. But what I'm seeing is, what's the same across the board is how the farmers are treated. And it really is, it's just you're there and you're in the way. And we need to get you out of the way so we can do what we want. And to me, there's nonstop fights and litigation to say, no, that's not how this is going to work. And those fights look like fights for money every time. And so the landowners are just accused of constantly wanting money, but we're in a capitalist society. And when you go to court, that's what you're fighting over every single time. It's either money or whether you're going to go to jail. So that's why all the litigation is about money. It's because that's how our system works. But the point is that the farmers, I think that one of the things that we should be looking at, and this is me soapboxing, but looking at getting farmers through right now as a number one, because I really do feel that the family farmers, we're losing them. Curt can tell you it's not stopped. We're still losing family farmers. And so to me, step one is preserve. And that's the sticky wicket. That's where it gets tough, is like, well, what if preserving means inviting a CAFO in to keep the thing running? That's a tough call for an individual farmer. I understand that, and it's easy for us to speak about high level policy issues. But when I first moved here to work for Sarah, the first thing she said when I got there is I was really keen on pushing organic agriculture and local foods. And she said, that's great, but you have to understand that most of our clients are not growing organic foods and they're using chemicals, and we're here to support them. Regardless of whether, they're organic or something like that. The goal here is we're here to support family farms. And so I think that a lot of what we're seeing in recent years, and I'll talk about it, is the energy industry is here in full force. And what I see is with coal companies, for example, they've been here long enough that they have these established sort of patterns and practices, and quite frankly, they are in control. And landowners, there's not much you're going to do with a coal company other than get bought out. And frankly, that's usually the best thing you can do, is relocate. But putting that aside, especially in the oil patch, I see a lot of farmers who frankly are millionaires now, and you wouldn't even know it because they're too damn busy running cattle to worry about all the money they've got. And so just as an example, one guy, he's like, I get so many pipelines, I don't know what to do with it. So I just buy stock in whatever company sold me the pipeline, or that I got the pipeline easement from. But the point is, like, for a lot of the farmers in the oil patch, obviously money is no longer a problem. But even then, they're struggling. And his struggle is, how do I ranch around 24 pipelines going through the same pasture? And when, there's 3 different pipelines on my property that are active at once and they're not closing gates, and I call them and they tell me to call someone else, what am I supposed to do? I literally can't keep my cattle in the pasture anymore. So I think that, there's definitely pros and cons that come with things like energy development. But I think that there are ways that landowners are benefiting from, wind farms or even disposal wells, things like that. What a lot of my practice has become is sort of fighting to maintain as much of that compensation and damages for the landowners as we can, because what the farmers are up against, and they don't even know it, is that the energy industries are doing everything in their power to reduce the amount of money that goes to farmers for energy development. that is a nonstop effort that they are making, is to reduce the amount they're paying landowners for everything, whether it's the oil patch, whether it's a coal mine, whatever it is. And to be fair, I mean, they're running a business too, and their business is not supporting family farmers. The reason I say that is that I think that there needs to be a growing awareness among the family farmers that you are engaged in a fight against, you know, the energy industry and these other industries. And it's not that they want you to go away or want to destroy family farmers or anything. It's just that they don't care about you and you're in their way, and they're going to do what they got to do to get you out of their way. And again, it's not even personal. I'm just saying brass tacks, that's the way they view it. They're an energy industry. They got something to do. But I think that a lot of times landowners don't realize that the amount of the pot of money that goes to landowners is determined partly by landowners being willing to fight, but also partly by landowners being willing to ask. And so often landowners don't get as much of that pot as they should, simply because they didn't ask. They didn't push for more money. They didn't push for better terms in the easement. And I think there really needs to be a growing awareness of the amount of power that landowners do have in these projects. And, you know, these projects, whatever it is, whether it's a wind farm or a pipeline, it doesn't happen without the landowners. You know, none of this happens without at least a certain chunk of those landowners saying yes to it. And what I have found is you've got to get landowners together talking about this, number one, to talk about that compensation. But the other thing I'll say is, you know, landowners need to talk to each other, but we also need to think about this in all of these issues in the context of what Curt has studied in the larger issues, because I do have concerns sometimes, for example, in the oil patch, where you've got, you know, someone that was really struggling before 2007 and probably wasn't going to make it. And now they've got 4 pipelines and they've got $1 million sitting in the bank, but they're going to buy a new tractor at some point. And so that money may not always be there, and the oil boom is going to go away. And so what you're setting up right now is this system where we've got family farms on the decline, but we're going to save some of them with payments from energy development. But that energy development, those payments, even the existing contracts are 30 or 40-year contracts. And so what happens if we've got family farms basically being set up and subsidized right now by energy industries and those energy payments? What's going to happen when those energy industries start going away? And so I'm going to be the first one to say literally what I do every day is to fight to get landowners more money from this stuff. So I'm not saying that's not a good thing to be doing, obviously, but I think we also need to recognize that that's not a permanent solution here. And it goes back to Liz, and the reason I pointed at Curt is that, you know, these larger issues are really a question of agriculture policy in this country. And ultimately, we're not going to change this stuff through lawsuits or even research. It's going to have to come from an actual shift in ag policy in this country, similar to what we saw back in, I don't know, what was it, 50s? Yeah. And I'm not saying it has to be that. I just think, you know, you have to shift in, you know, to me, you always see this discussion and debate where Farm Bureau says, well, they're just opposed to modern agriculture and in industry and technology. And the other side says, well, you're just destroying the family farm community. And it's like, you know, it could all be true. But the bottom line is that, as Curt knew in the 80s and knows today, the industrialization of agriculture is going to squeeze out the family farm and rural communities. That's it. And so the question is, are we okay with that? I think that some people are. And I think what we're saying is we're not. But I think ultimately, Liz, the answer to your question is it's bigger than us. And
I also want to add that I think we need to be thinking about the role of government in this battle between, say, landowners and development. And right now, I think many of the elected officials and appointed officials in North Dakota see as their clientele the developers, typically who come in from out of state, and they celebrate when even foreign countries come in here to invest. But I think that right now, I'm just feeling that there is less political recognition that government exists to serve the citizens. then and there's just too much emphasis on government is here to serve the gross domestic product of the state, you know, like, is everything good if income, gross income goes up? Or are they ever gonna look at net to the people? But there's, you know, like the idea of the citizens being preeminent, I think that's been kind of lost in state government in particular.
What I've seen here in the last 3 or 4 years, so what Sarah just said, I would have said 3 or 4 years ago, that's absolutely the case. But I think that in the last 3 or 4 years, there's some growing recognition that if you keep pushing landowners, they're going to start pushing back. And
Yeah.
I think that even the Legislative Assembly has recognized that at some point, the farmers and ranchers are going to start getting vocal, and that's starting to happen. And I think they're seeing that with some of the eminent domain stuff.
Forest things, you can talk about that for a minute.
Yeah.
Yeah, I mean,
By the way, good
Yeah.
job there.
but I
Have
mean,
you explained what the Poor Space lawsuit did?
no, I'll cover that real quick, but you know, back in 2019, it really goes back further than that. So I'll tell the whole story, but there were a couple of cases in federal court, the Mosser and Fisher cases. And the federal courts basically made this decision that in North Dakota, they're going to allow operators to put oil field disposal wells on a landowner over their objection, but you still have to pay for it. And Continental Resources did not like that decision that they had to pay for disposal in their unitized fields. So the Fisher case that sparked that with Continental sort of went by the wayside, and they settled on some of it. And Continental said, we're just not going to use the well. Then in 2018, in November, Continental started using the well again. And then Continental actually sued the Fishers, saying, we don't have to pay you and we're going to keep using the well. Well, there had already been a whole lawsuit with the Fishers where the court had ruled that Continental had to pay them. So everybody was very confused. And the Fishers attorney at the time called up Continental's attorney and said, this doesn't make any sense. We literally had this lawsuit and you lost and there's a decision and you're just bringing the same motion again. Why are you doing this? And the attorney for Continental said, we're pretty sure the law is going to change. And it did. In the 2019 legislative session, they got the pore space bill introduced, Senate Bill 2344. And that basically just took away all rights to pore space from landowners. And so Continental literally knew that legislation was coming down the pike and filed a lawsuit 3 months before the session even started, waiting for it to go through. So the Fisher case ended up being put somewhat on pause while this was happening, and the federal court was watching what the state courts were doing. And so following the session, the Northwest Landowners Association filed a lawsuit to strike down the pore space law. And then that wound its way through a district court and state court first. And the state court judge struck it down and said it's unconstitutional. Then Continental and the state in the AG's office appealed it to the state Supreme Court. And then recently the state Supreme Court also agreed, struck down the law, and it is now official that it is dead law. So what I can say is, since all that happened, when I hear legislators talk about anything that comes close to takings or eminent domain, the first thing is just, well, we don't do takings. I'm opposed to eminent domain. And so I think that and I don't think that it's just the Northwest Landowners lawsuit that had that impact. I think it's also just this growing awareness among landowners about how eminent domain is being abused to ramrod some of these projects through. And so I think that it's partly that, but I think there was a lot of backlash from both that and just landowners getting more and more upset about this idea that private companies get to use eminent domain. And I'll tell you, I don't usually get really angry landowners calling me because DOT is putting in a road. I mean, they might recognize that they don't want that road there, but they don't complain that DOT shouldn't be building roads, damn it. But they do get upset when it's some private company that's making millions of dollars by running a business on their land, and they're going to use the government's power of eminent domain to take it. And I think that the legislators and, well, no, I'm going to say the legislators, I was going to say the executive branch, and I don't think that's the case. But the legislators are starting to hear that. And I think it's a very good message, and one that should be amplified whenever possible, because I think it's having positive impacts for landowners.
For Derek, are you confident that carbon capture technology storing CO2 underground is environmentally safe? Is your work in the Northwest Landowners Association primarily aimed at the monetary compensation and not possible environmental consequences?
You can refer him to Braaten. Come on, this was relatively easy. He's asking as a legislator too. Just full disclosure, Merrill's a legislator.
Yeah, I know. What I would say, and I'll say this to everyone, is I have a client in Montana in Denbury's Bell Creek field. They're doing a CO2 flood EOR operation. And they use the CO2 because it actually works better to push out the oil than just doing like a water flood or something. And they're going to bring that technology up to North Dakota. One of the concerns I have directly to Merrill Pepcorn's question is, when they do the EOR stuff, they're not looking at, is this a solid storage area for permanent sequestration? They're looking at, we got an oil field here and we want to get more oil out of it. And so there's also this process whereby they can convert an EOR field full of CO2 to a permanent storage facility. And one of the concerns I think a lot of folks have right now is, it's one thing if you're doing CO2 sequestration as CO2 sequestration starting and ending there, and that's what you're focusing on when you're looking at the seismic and the science. It's another thing if you're taking an old EOR field that they've been doing this in because that's where the oil was, and now there's a bunch of CO2 there, and you're like, let's just leave it there. Is it going to stay there? I doubt it, frankly. And what I mean is, you got literally pin cushion. I mean, that area is pin cushioned with wells from doing the EOR operation. So I would think that's about the last place you want to leave that permanently. So I think that I have environmental concerns when you're talking about some of the EOR being converted to CO2, where they're not even studying how they're going to keep it there. What I will say, though, is I do think that, in terms of keeping the CO2 underground, 40, 50, maybe 100 years, I think the technology and the science is pretty confident that we understand that. That's not to say you're not going to have a leak. The more of this we do, the more you're going to see leaks. It's the same as a pipeline, they leak. But it's more like, you're going to have a catastrophic leak, something like that. Where we've seen catastrophic leaks of disposal water into aquifers in the oil fields, it's in old oil fields where that stuff starts to come up old wells that were plugged 40 years ago and were plugged very well, and now the plug is gone. And so there's all of these ways that stuff can start coming back up to the surface from old wells. So that's where I see the potential for environmental problems. The reason I brought up my client in Bell Creek is he's literally in the midst of an EOR CO2 flood with pipelines and stuff going everywhere. And our concerns on that ranch are not with the CO2, it's with the salt water that gets spilled. And he's had some CO2, pipelines explode, because that's what they do. It's kind of cool actually, but the CO2 starts to push up to the surface and it creates this bubble almost. And sometimes you can just get this huge heave of gas that pushes up a piece of the ground. And then they just got to go in and dig that out, and they're literally cleaning up CO2. So again, it's better than having salt water there. But he's also had one of those things blow up literally in one of his ranch roads. And he wasn't driving at the time, but it literally took out maybe a 7-foot deep crater from half of that road when it blew. Now, part of the problem was Denbury was using fiber, and fiberglass pipelines are bad, just don't. And they've started switching over from those, but what they were finding is that those pipelines would build up moisture, and as they built up moisture, it would start causing these explosions and this pressure buildups. So like there's concerns, but again, like these are not like if I'm talking to my client, the landowner, his concern is not that CO2 line blowing off on his ranch road. His concern is the saltwater disposal, it's noxious weeds, it's the kind of things you generally hear from farmers and ranchers that they're upset about. And it's not, you know, he's concerned because they screwed up one of his reservoirs and they've got spills all over the place and they're not getting the weeds sprayed in time. And so I think environmental concerns from energy development, a lot of it is similar for farmers. And it's not what you'd think that I hate oil or I hate coal or I hate wind. It's that you brought gravel in and it had a bunch of seeds in it. And now I'm pissed about that because I got to deal with the seeds for the next 30 years. So I don't even know what my point was when I started at this point, but
No, he was asking you whether or not you think this is safe. And then-
I think the long-term question is, you know, is it all going to stay down there permanently without migrating? The technology tells us that in the near term, we can do enough to know it's pretty safe. That's not to say you're not going to have leaks, but any project like this you've got, there's going to be times when it doesn't go as planned. But I don't think that the fundamental concern with CO2 sequestration is the immediate environmental impact of building the infrastructure. I think it's the long-term concern about whether that CO2 stays in the ground and what happens if it doesn't. And also just there's a lot of, and I don't need to tell this room this, but there's a lot of layered policy issues with CO2 sequestration where even environmental groups oppose CO2 sequestration because it limps along fossil fuel industries. But you also have environmental groups like EDF that say, well, whatever it does, but let's do it anyway, because this is the best way to address it. And I'm not going to get into that policy debate. My only point is that there's a very complex layered policy debate going on around carbon sequestration. But ultimately, in my view, there's a lot of pros and cons to talk about with carbon sequestration, but I don't think that, let me put it this way, I don't think that the immediate environmental impact of carbon lines and carbon sequestration is any greater or different than pipelines and saltwater disposal wells in the oil patch. You know, we're really talking about a lot of the same things. And
the one thing I'll say too, just to piggyback off that from Elliot too, is there's literally no rules for CO2 pipelines compared to other pipelines. So that's one concern that we've had is like there is no real federal rules dictate, like essentially like trying to make it safer, right? Like that's the whole purpose of those rules would be to make that safer, especially with the new Summit pipeline coming in, which is magnitudes bigger than anything you're talking about, right?
in what happened in the Bell Creek field with Denbury is a really good example of what you're saying, where these pipelines exploding and taking out half his road. Like, again, it's not like it's happening every day, like popcorn or something on his property, but that's happening. And it happened because Denbury was using fiber pipelines for these CO2 lines. And what they learned, because there was no regulation saying use something else, they learned that was a really bad idea and it caused all these problems. And they learned that because there are no regulations saying that for a CO2 line, here's the material you should use. So there is validity to that. And I think it's more a question of we need to start thinking about that and working on that.
The Inflation Reduction Act has all kinds of stuff for clean energy, but it also has a massive carve out for carbon capture pipelines. So carbon capture pipelines, Heidi Heitkamp and others in North Dakota, in our federal delegation, we're actually responsible for the 45Q tax credits, which are what it was Hovind and Heitkamp were two of the authors of those tax credits. And those tax credits were intended for really for our coal plants to potentially do carbon capture there. But what happened is that they originally got the tax credits at $50 a ton of carbon that you get for sequestration. And that's for permanent sequestration, not EOR, which is enhanced oil recovery. And what happened with the Inflation Reduction Act is they moved it from $50 a ton to 85. And that 85 is no longer a tax break, it's a direct payment to those companies. So Summit Carbon Solutions, for example, I think Elliot has his number, but it's about $1 billion a year is what they would make in the first 8 years just off those tax credits. And then those tax credits could they're similar to the PTC, the production tax credit for wind, where they can die if it expires, or it could just get renewed forever, right? PTCs gets renewed like every 4 years, 5 years or whatever, or every farm bill, wherever it's in. And it's always a policy debate, et cetera. But these tax credits are much bigger than the PTC. like much, much bigger. So, and it literally, it's 75% of their business model is these tax credits. The other 25, I've heard both multiple numbers, but the other 25 or 30 or whatever it is the low carbon markets in different states. So like low carbon fuel markets, etc. And Jane will probably talk more about a lot of this later. But that is, so just to like flag that, like that it's a national thing that's being pushed. Some people in politics say it's because of Joe Manchin, but I think it's really because both parties are actually looking at this as a solution. So yeah, not necessarily on the pipeline.
Just so that everybody here in the chat understood, Elliot was just saying that the write-off for the first 5 years would be a check for $1 billion.
It's not a
Direct.
final, it's a direct.
Yeah, direct payment. And it would be $1 billion or $1 billion per year.
Be $1 billion annually if they meet their goals of capturing.
If they meet their goals for capturing, they would get $1 billion per year for the first 5 years, and it would be a direct payment rather than a tax rebate.
Probably the last question, then we'll take a break.
Yeah, actually, I've got one from
So
chat.
we'll do Jake from the chat.
The chat is a very simple one.
Okay, do the
Is
chat.
that,
Jake's like,
Olivia asked what regulatory agency would cover this carbon capture pipeline.
The North Dakota Public Service Commission is doing the siting proceedings. Yeah, Scott's right. I mean, is PHMSA covering the pipeline safety for
yeah,
CO2?
there's a rulemaking that's
Okay.
going to start this fall.
Okay, so PHMSA is a federal agency on safety. And then the
FERC theoretically could.
Okay, we're throwing around acronyms without saying anything.
Federal Energy Regulatory Commission, if they decide to list carbon pipelines as a regulated pipeline, if they're interstate.
Okay, that'd be good.
So that's the other one, like for my
If they're
knowledge.
going to. Okay, and then the Industrial Commission is the one that does the underground injection control program. And so the sequestration area will be the Industrial Commission, the pipeline siting, the PSC. Let me say something real quick about that, because I hear this, and I think Jordy has probably explained this to folks, but the PSC doesn't actually give them eminent domain authority. They probably don't have eminent domain authority if they don't have that siting permit, because if I were representing a landowner and they came in, I would say it's not ripe yet. If you don't even have a permit, you can't come in and condemn land. But it's not the case that the PSC actually makes a decision, yes or no, on eminent domain. They just go through their siting process and cover that. And generally the way they view their siting process is it's almost a required rubber stamp. And unless you're going through prime farmland or something like that, they're not going to do much other than I do think landowners have had success getting reroutes on pipelines from what I've seen. If you've got a landowner that just comes in and says they're going right through this 90-year-old tree on my property, and I asked them if they could tweak it 10 feet and miss it, and they said no. And that's the kind of situation where sometimes those commissioners say you're actually just going to do that and you need to miss the tree. But I just wanted to throw that out there because I hear a lot of folks asking about the PSC and eminent domain, and just wanted to clarify that one point.
And North Dakota laws for injection wells.
Can you say that again?
The primacy laws, North Dakota for injection wells.
Yep.
Yeah, for
Just
class
repeat
six.
that. How do primacy laws?
So,
Repeat the question there.
yeah, so the question was just about primacy in North Dakota and the underground injection control program and whether we have primacy. So what primacy means is that the underground injection control program is a program that covers injection wells, and whether it's a saltwater disposal well or a freshwater injector for a water flood operation in the oil field, or a hazardous waste injection storage area that you're going to put hazardous waste underground, or a CO2 injection well. These are part of the underground injection control program. They have different classes of wells. Class 2 wells are your disposal wells or your freshwater injectors, things like that. EOR, I understand, is done through Class 2 wells. That's one of the other issues we can get into, but Class 6 wells are your wells that are going to be injecting the EOR for sequestration. In North Dakota, we're one of the few, if not, well, no, I think there's a few other states now. We were the first. We got primacy. What primacy is I'll just say it very generally, with a lot of environmental laws, for example, the Clean Air Act, the Clean Water Act. The federal government adopted these laws, but then each state adopts its own version. And as long as the state has a version consistent with the federal program, the state can run the law itself. So that's what North Dakota does with the underground injection control program. We have primacy. And so it's the North Dakota Industrial Commission that does that program. And so if you want to get a permit for a saltwater disposal well, or for one of these class 6 injection wells to pump CO2 down, you got to go through the Industrial Commission to get those permits specifically. And it's because they have primacy. And so you don't have to go through the federal, EPA or something like that. You just stick with the local agency and their laws.
Would be self-monitoring then too?
Self-monitoring. I don't know on that one. Generally speaking, yes, it's going to be the Industrial Commission and their folks doing monitoring. But one thing I've seen with the Class 2 program, for example, when they're doing a disposal well, if they're doing a disposal well into a freshwater aquifer, they have to get an aquifer exemption, and they need to get EPA concurrence on that. And so there may be some things over long-term, and I would think, for example, if they're going to transition something to long-term liability with the state or do some sort of transition, there may be some EPA involvement at that point. To the extent there is, it's going to be just sign off, meaning EPA will need to look at what North Dakota is doing and just say they approve or don't approve, and they'll approve.
I guess we can probably take a break. So we'll take about a 10-minute break, and then we're gonna come back for organizer reports. So the organizers are gonna talk about some of the campaign successes and then next steps for the next couple years. But for now, we'll take a break. There's some snacks and stuff over there. I think